Dear guests, ladies and gentlemen, welcome back after the break to the European Data Summit. As you know, the upcoming Data Act has another part which is devoted to the so-called business-to-business data sharing. I'm glad to introduce the next speakers, Jörg Hoffmann from the Planck Institute for Innovation and Competition, Christian Reimsbach-Konatze from the OECD, Michael Dose from the Federation of German Industries, the BDI, and this panel will be moderated by my dear colleague Begoña González Otero from the Max Planck Institute. Dear Bego, the floor is yours, the virtual floor.
Thank you, Pencho. Thank you very much. So I have the feeling that Christian still couldn't join us, but I hope he will eventually very soon. So, well, first, thank you. It's an honor to be here, even if virtually, at the head of representation of the European Commission. And so without further delay, before we start with the discussion with our dear guests, I would just like to recap a little bit and set a bit the scene when we're talking about the issues regarding B2B data sharing. So, and especially because we're at the head of representation of the European Commission, I mean, it's a kind of must that we need to use digital commissioner and also German lawyer Guten Oettinger, who back in the day already stated that data is this infrastructural asset for the digital economy. I mean, he was one of the first that referred to data as a new oil and asked the question up front, what our legal system says about that. How can we capture the value embodied in the data? And if we're talking today about Data Act and different regulatory approaches toward more data sharing, I mean, we owe that in part also to him. Around the same time that Oettinger came with this idea, we also, maybe many of you know Professor Yuval Noah Harari. He is a bestseller author and a philosopher. And at the Davos Forum, in the World Economic Forum, he already warned about the risk of big data and the future of humanity. I mean, he said that those who control the data will control the future, not just of humanity, but the future itself. And this is quite of a big statement. And this is because data is the most critical asset in the world. So in this scenario, one of the key questions is how do we manage data as an asset in the society and the economy? And because if we don't consider this question, and that's why when we're talking about this Brussels effect, it becomes so relevant, we could be overwhelmed by unexpected reactions and unwanted disruptions. So how do we design a system of distributed fairness? Now we have heard Francesca Bria today, so other speakers touching upon this concept already. So when we look at the current debate, both at the regulatory and the scholarly level, what can do is identify 4 different dimensions where data as an asset plays a critical role. And the first dimension is the digitization, the Industry 4.0, the digitization of the value chain, where the Internet of Things is one of the most evident examples. A second dimension, what we can see is data-driven innovation that is based on the repurposing of the use of collected data. There has been a fantastic discussion about also this combination of data and what might happen from the DMA perspective. And we have also seen examples in the automotive sector, also in the financial sector. So probably we can hear more about that from our speakers today. We also have a third dimension where AI and the big data morphing into AI, it's also key. So how can we foster AI training and development? And of course, the fourth dimension, going back to the DMA, it's the arrival of monopolization differences. Who controls the data? How do we distribute the value of data that is generated? Is there too much accumulation? That has also been discussed along the 3 days of this summit. So when it comes to B2B data sharing, it seems, however, that there is an issue there, that the sharing or data access of private data is not working as well as it could. There are several reports that have pointed into that direction, and others that also point to the existence of market failures and also the need for regulatory intervention. So with all this scenario in mind, I would like to get the thoughts from our still two speakers at least. Let's see whether Christian can join us. That will be fantastic. But for now, I mean, I would like to gather the thoughts from Dr. Michael Rosser, who is representing here. He's a senior manager of the Bundesverband der Deutsche Industrie. So he's representing the Federation of German Industries, and also from my dearest colleague, Jörg Hoffmann, who is a research fellow, a colleague of mine, and he has a lot of contributions on how to safeguard innovation via data governance regulation. So my first question is, with this scenario in mind, do you think that this scenario that I just depicted, it's a right one, or did I make any false assumption? Do you think there is a need for legal intervention? And if there might be, based on your own experiences, do you think there is a right, wrong regulatory approach, hard law, soft law, horizontal approaches, sectorial approaches? What are your thoughts on that? Please, Michael.
Yeah, thank you very much, Vigo. And first of all, thanks for the invitation and the organization of this summit in these tough times. Really much appreciated. I think we can agree on this scenario you suppose. Regarding B2B data sharing, we totally agree on the fact that we need more availability, use, and exchange of data to realize somehow the full potential of the data economy in Europe. And therefore, we totally support the idea of the European data strategy, which has a very holistic approach with the legal framework as the first pillar, the trustworthy cloud infrastructure as the second one, competences, which are quite important, the third one, and the developing of data spaces as the fourth. But as you have mentioned, we have a very, very complex ecosystem, which is very much under construction and which is very much on developing. And if we now have a look at the regulatory side, we have to take this into our mind that we have a heterogeneous industry landscape when it's about use and exchange of data. We have several business models with different interests of the parties, and the best way to solve those different interests is to make specific contractual agreements, so B2B data sharing in case of voluntary B2B contracts. But we also see that we have different kind of ways how to share data. About intermediaries, the summit has discussed this before. We have a lot of B2B platforms, such as IoT platforms. We as a BDI just published a paper where we put out just over 100 German digital B2B platforms. We have the upcoming data spaces. So we see that there is collaboration ongoing in and between the sectors. But as you mentioned before, we see also that we have uncertainty in the market. And so this is how does the data economy fit with the regulatory current framework, with the ongoing initiatives. And when we now have a look at the upcoming Data Act, so we don't have the proposal right now, so it's like a little bit like a prediction, but what we can say is, for us, we don't see like a structural market failure in the B2B sector that would justify a very strict horizontal approach within the Data Act. So maybe these are the first words.
Thank you, Michael. So what is your take on that, Jörg?
Yeah, so again, also from my side, thanks a lot for the invitation. It's a great pleasure to be here, and thank you for putting such a nice summit together. Yeah, so so my quick reaction to that would actually be, I mean, you depicted so many different scenarios, Vigo, that somehow I think are extremely difficult to address within one law. And I think this is also one of the biggest issues that we are currently facing, that looking at the different potential ratio legacies in the laws, it becomes extremely complex to assess it from that perspective. And I think this is one of the key points that we need to talk about. So what is the ultimate goal eventually? And now taking on Michael, I mean, looking at the DMA, we are really looking at disparities of bargaining power. So we basically have this B2B constellation in mind. There comes a lot of different scenarios that are still not really clear. I think a wonderful example that we can take as a reference point in here is also the current debate that we have in Germany and that we see with the 10th Amendment of the Antitrust Code, for example, where paragraph 20 and the concept of data dependence was also developed. And also here, I think it's extremely difficult to really assess what data constellations are actually envisioned. And I do agree that there is a lot of heterogeneity, and I also do agree that there are a lot of different data constellations in place. And I think managing or kind of trying to develop a legal system on such a horizontal level that really takes due respect to actually the kind of issues that come with specific data constellations is one of the biggest tasks that we are actually having. And I think exactly there, the first thing that really is important is exactly what is the eventual goal that we are aiming for? And is it somehow an obligation for undertakings to foster innovation? I think that would be something that we really need to be clear up front. You also see that in the different options that are currently being developed. Or is it rather something where we are only looking at specific IoT constellation with very complex stakeholders involved? I also see a lot of third-party constellations in there that are still not sufficiently addressed. And I think here it becomes extremely relevant. Also, you talked about the innovation aspect of it. I mean, AI pretty much has a lot of potential, but we are not talking about data that might be needed for actually training certain AI-specific purposes. So I think there's a multitude of different constellations. We just need to be really clear on what is the take on the legislature on that. And then we need to conceptualize that better within that reality that we are currently living in.
Good, thank you. I mean, yeah. So I think it's a really good takeaway. You know, so first, we need a clear goal when it comes to regulatory intervention, and second, the need for really try to conceptualize, because as you both pointed, we have such a huge amount of so complex dimensions and scenarios that need to be addressed, and not all of them. So one size fits all, it won't help here. No, that's exactly. So you also mentioned. You also mentioned, Jörg, that third-party constellations are also really important, and on that I would like to follow up on something that also in a report from the BDI was pointed, if I remember based on conversations with Michael also, that when we look at fears also from the private sector in order to share more data, that there are normally privacy concerns. I know GDPR has been discussed during these past 3 days a lot, but I think it's also important that we take upon here privacy concerns, but also fear that trade secrets or misappropriation by others could be also here when we're sharing, or when companies are sharing data. So do you think, legal intervention, it's a solution here, or we should let the market try to solve this problem? Or, how could these fears be overcome? What will be your take on this aspect, on these fears, to share?
Yeah, thank you very much. You mentioned it totally right. Yeah, we have these uncertainties regarding the current legal framework. You mentioned the GDPR. We have the same discussions with cooperation, which we need to increase the data use and exchange. We have to cooperate, and also competitors in the market have to cooperate. And then you have the competition side. So where is the how far can you go with the cooperation to not get punished from competition law side? And to make a little bit evidence, or to give a little bit of evidence in this discussion, we published a study starting this year together with the IW Köln Institut der Deutschen Wirtschaft called Datenwirtschaft in Deutschland. And what we found out in a representative survey out of 500 industry companies, that only 28% of the surveyed companies are digital regarding the data management. So they have the ability to deal with data somehow. So yeah, so they are just those 28% who can take part or can participate in the data economy at all. And we also asked, this was the second part of this study, what are the big obstacles you see when it comes to the economic use of data? And 85% of the companies gave the answer that we have legal uncertainties regarding the GDPR, so that we have like gray zones, gray areas in the GDPR. And my interpretation of this, and this is also something we have to keep in mind when we're talking about the Data Act and in this uncertainty discussion we are now doing, is it is not about decreasing the level of data protection, which is needed. It is even more to find technical solution, to find bridges which where you can have a very high data protection standard, which we have in Europe, but even as well have the opportunity to use and exchange data in an economic way. And for this reason, data anonymization comes into the discussion, in my point of view, because this is a nice tool to foster both aspects. You are out of the GDPR because there's no personal data anymore, and you can use the data for economic purposes. But right now, there's a big uncertainty on how anonymization in practice is what kind of anonymization level is needed to be GDPR compliant. So there's also a lot of uncertainty, and what is happening in the current situation, that companies refuse to deal with a business case when they want to do some economic aspects on using and exchanging data, because of the possible law break in GDPR or in competition law. And I think we have to find those bridges that makes the current framework, from the current framework to the new framework when we are looking at data exchange and data use.
Thank you. Good. So any reaction to that, Jörg?
No.
Wait a second, because right now we cannot hear you. I think there is a technical issue.
Can you hear me now?
Yes.
Excellent.
Thank you.
Yeah, I mean, I do agree that there is a lot of legal uncertainty if we talk about data protection. I mean, anonymization pretty much is actually what is one of the key solutions to that. But I do agree that we still have a lot of uncertainty. And also, I think we need to think that a bit broader again, that also what happens if I have certain specific usages of data. And I think there is also, at least from a scientific point of view, some new work been done from an econ perspective, where, I mean, also anonymized data can at some point have certain detrimental effects if you use it, for example, with the big techs that might actually have better insights, and they can come up with some personalization and pricing that might also be actually able if data is still anonymized. And I think here the question would rather again be like, what data is really needed and what are potential adverse effects that also come with the data. Yes, so that would be probably the go from a scientific point of view, but I still do agree that the GDPR it's an extremely valuable tool that we have. And I mean, we heard over these days that it's currently being updated. We still have a lack on enforcement. We still have a lack of clarity on a lot of different views. So we see that in the Facebook case, for example, where the purpose limitation is pretty much now being more generally discussed also from the CTU in that case, which eventually hopefully gives us a better understanding of these really abstract principles. So I somehow do agree on that. I think also regarding some other points, because you mentioned, for example, I think one is the IP sphere, where we need to talk about intellectual property and particularly the database sui generis right. I think I'm really happy that the database sui generis right is being addressed in the Data Act. I think here it's not very clear what is meant with machine-generated data in general. We need clarity on that part. From the very beginning, and I think it was quite clear, always kind of criticized also from the scientific sphere, that the database sui generis right had pretty much like dysfunctional effects in any ways, and we were questioning whether the kind of innovation incentive that should become with it is actually really working or not. And I think this is clearly now a good and a right step forward. Yet I also think there are other copyright laws that we need to think, and one relates then obviously to the database work. So far, the legal threshold for originality is quite high, so we don't have the sweat of the brow concept anymore, which kind of set a really low standard. But nonetheless, I think here we also need to assess what exactly is then being protected under that sphere. And here limitations and exceptions under the DSM directive are just not really well drafted, and we still have possibilities to overcome that by contractual means. So it also is something that I think here again, we should broaden up the debate, plus the content that might be actually be protected by copyright. Here, we need clarity on that point as well. And then obviously the API discussion is really back on the table. I mean, it should not be protected under copyright. I think we had the SCOTUS decision that rather is not really focusing on that point yet. I think also in the European case law, it's quite clear that the merger doctrine and see non fair was pretty much telling us that no, we don't have that yet. I think it's clear. It's not clear as well whether it might be software protected or not. So we just need clarity on that point. And I think, yes, what would be the right way in the very end? I mean, I think if we have the access regime, we should be pretty clear that this one's the prevailing kind of system in that context, instead of having the duty to then license something in parallel again. So we kind of need that to be cleared up front. Again, and yeah, that would be my go on it. Yet also, I mean, still, what is still important, despite this idea of creating more access and these commons that are currently also being discussed in the scientific sphere, that we should pretty much open data, because it might create actually the value of a lot of firms. This is also something that is more and more in the discussion. I think here, yeah, we still need to look at really the investment incentives, but also assess whether they really are there. And I think the Latvian case, for example, can be a nice example where the Court of Justice pretty much looked at it with a more investment incentive perspective on it. So I also think here, yeah, there is a lot going on, but we need to be clear on a still couple of points that are not solved yet.
Thank you both. At this point, I would just like to call back Pencho, because I see that we're running, time it's flying actually. And I do have one more point that I would like to address, but I don't know if you want to open the floor to questions, Pencho?
Sure. You have enough time, so please continue.
Okay, good.
Till
so,
2 p.m.
Oh, wow.
Yeah.
Fantastic. So, I mean, one of the other, we need, inevitably, I think, we need to touch upon these leaked documents that, I mean, from the Data Act, you know, these, at least some aspects, you know, of this impact assessment that it's all over the internet. We don't have a legal text, that's for sure, so we don't know exactly what's going to come. But it seems that when one reads through the lines of this impact assessment, and also, you know, many of the other documents that have been published by the Commission during the data strategy, you know, within the data strategy and these policies, there is an idea of fairness, you know, behind. You know, these, like the European Council referred to this greater and fair use in B2B in particular, no data for the benefit of society, you know. So I would like to get your take on that too, because when we're looking at the constellations in business to business, and we, of course, I mean, fairness as a society goal, no, it's something that we all want, let's say. But when we're looking into this particular constellation, no, when we also have the freedom to run a business, and suddenly we incorporate maybe fairness, no, from a more obligatory point of view, let's say, no, then things start like crushing, no, or making a bit of noise. No, they are not so smooth. So what will be your thoughts on that, Michael and Jörg?
Yeah, I think regarding fairness, I think we have all the common understanding that we want to have fair contracts. But at least I'm not sure if we're talking about B2B constellation, and even though B2C constellation, I'm not sure if I have signed any contract. I also signed contracts where I had the feeling that it's not really fair what I just do. And in the B2B context, we have to be very careful to regulate in this field, because I think freedom of contract is a very core value in contract law, or in European law especially. And yeah, when we had a look at the first documents of the European Commission from the inception impact assessment and the public consultation, we were wondering, because the B2B fairness test was linked to the situation that you have an imbalance in bargaining power. And this is something where I have not understood what will be the scope. Yeah, so it's quite normal that also in B2B constellation that you have a difference in bargaining power, but this doesn't lead at all to the fact that you can have fair contracts. And I think this could also lead to a lot of uncertainty, because, yeah, where's the scope of bargaining power? How do you describe it? Is it the sales revenue difference between those companies? Is it the size of the companies, or the amount of data? So that maybe a small and medium enterprise has a high bargaining power against a bigger one. So I think. Yeah, it's like a prediction. Yeah, we have to be very careful to try to make like a fairness issue in this whole data ecosystem, because I don't think that fairness is like a sufficient legal term to fix the problems that we really have.
Thank you, Michael. Jörg?
Yeah, it's very interesting, because it goes back to kind of the first remark that I did, because it again really relates to the goals that we envision in that. And I agree with Michael that the fairness concept is quite, ambiguous in that context. If we really follow the track of B2B constellations and disparities of bargaining power, then obviously, yes, we need to look at this particular relationship, and then, assessing it is difficult. But again, if it comes to data sharing, I mean, public interests are involved, and that's also true. So if we do share data, general welfare is actually increased in at least certain circumstances, and that kind of makes it more complex to assess fairness in these contexts. And I mean, we currently see that in the DMA, where we also talk about fairness, and it's at least, I mean, looking at antitrust laws, for example, we always had a concept that stems from individual economic rights and also kind of the more general public interest behind it, because open and competitive markets actually help for innovation and to create more competition. And I think this is exactly what we also need to like overcome and reconceptualize in the context of data sharing, because fairness might mean something else. And it not only becomes relevant in the access constellation itself, but also on the modalities of it. And I think here, I mean, a front test would be extremely interesting, but what does front actually in that context mean? Again, right, like with a more competition-centered viewpoint, you have United Brands, you kind of have the cost-profit test, and then you assess specific, whether kind of the cost, what I pay and the economic value in the end are reasonable. So that relationship should be reasonable. And I wonder how to actually kind of measure the economic value in data, because we still don't really have comparative markets to assess what fairness from a price perspective might mean. And also, I mean, looking at really complex systems in data sharing constellation, the question will ultimately arise: who am I supposed to share my data with? Is it only the person that I'm currently contracting with? We have that in Article 20, for example, where really last minute, or like where at least a discussion came up, and now it is in the law that you don't actually need a contractual relationship. So what happens if we don't really have that and you still get access despite not having an already existing business relation? And I think these are just, again, a lot of questions that need to be raised and that we really need to answer in that context to get clarity. Because for me, again, fairness has a lot of different connotations. It's a conundrum in some way. And in the end, I think we really need to, again, be clear and need to conceptualize it better in the data access constellations that we are looking at.
Good. Yes, indeed. So we're, again, going back now to this idea of conceptualization, which is key when we're looking at these, in specific, not to this legal upcoming text or proposal, this regulation, the Data Act, and clarity on goals. No, that's one of the two of the main takeaways that we have for now. But now, because we want to have some time for questions, but I would like to kind of wrap up these with you trying to be a bit more utopian, no? So, you have your own experiences, you have done also a lot of research, either from a more practical, or theoretical, and you have read a lot about that, you have been very involved. So if we look at the upcoming Data Act, we have some documents around the INSEP impact assessment, the draft. We don't have the legal test, but if you will have to be, utopian and in your personal opinion, based on your own experience, what do you think might be 2 or 3 key considerations on top of goal orientation and this need of conceptualization that when we're looking at this scenario B2B, regulatory tool, let's say, should consider? And what do you think might be important shortcomings? So what to do, what not to do, that to do and not to do that from a policy perspective, So whoever wants to start, please.
Okay, I can start. Yeah, thanks. I always wanted to be a legislator, so thanks for the opportunity. Well, regarding the Data Act, I would suggest to really have a clear view on this whole ecosystem, and to not to look only on the legal side, also to impose the economic and the technical aspects. And we always have to keep in mind that we have to find a balance between the interests of the companies, of the data holders, and the companies who want to have access. Yeah, both parties have legal claims. They have interests, and you have to balance it. And you really have to take care that you, with a horizontal approach and a horizontal regulation, that you don't destroy these small plants that are coming out of this data ecosystem. The second one I mentioned at the beginning, try to harmonize it with other legal frameworks, which are for now are not in the core perspective of the Data Act. I just don't want to repeat it, but these are the things I've said before. This is kind of a very, very important stuff, that we find a right balance. And yeah, maybe I leave it at this for now.
Okay, thank you. Jörg?
Yeah, Michael, now it's a bit difficult to add on something on that, because I do agree on a couple of things that you just said, because I also see that we really need to be specific on the data constellation, because in certain constellations, we simply don't need a kind of extremely specific technical design of access. In some others, we really do need real-time access. We need the APIs. We need standardized APIs, ideally. And this again, it really reflects again on really the specific scenario that we're looking at. If it's for just making enforcement pretty much workable, like Article 15 of the GDPR, for example, is looking at, then we don't necessarily need actually extremely high developed interoperability obligations. Whereas in other cases, it's extremely important. And I also see that, for example, in the PSD2, it's a wonderful example where real-time access is actually helping a lot. But here it's again interesting to see that there are a lot of other interests implied where, it's about engaging consumers, about really furthering switching of consumers in certain circumstances, because here, these are different interests again, and this makes it again so difficult to address. And this is also, I think, one of the key takeaways or remarks that I want to draw is we also need to overcome that issue that there are certain already existing kind of sector-specific ecosystems in place, and we add now a horizontal level on it. I do agree that we need cross-sectoral data sharing. It's really wonderful, but I'm still wondering how to overcome specific issues that arise with the standardized data, for example, that we have in specific sectors, and how to really make that feasible on this horizontal level. And I really have the fear that, and this also goes back to what Michael said in the beginning, that only 28% of German companies are actually kind of ready for making use of these services. And I really wonder how we can create a really inclusive policy in that. I think one first step is clearly, I mean, opening up data and making it just possible. However, I'm also wondering what potential adverse effects might be, because in the end, it will actually benefit already existing kind of really fit companies and in that sphere. And I am a fan of, again, like cross-sectoral data sharing, but again, we need to be just aware of potential adverse effects in that context as well. And I think last but not least, again, I think it's important if three parties are involved in a lot of different constellations and we only look at two of them, I wonder what that means from a liability perspective. I wonder what it means from a perspective of enforcement. Is it better to design these rights for the third party, that what we typically have in antitrust constellations, for example, because they better know what data they need, what actually access they actually need, and whether we don't necessarily have this principal agent problem in certain circumstances. And I think here, being really clear on this third party again should also be one of the key considerations. And ultimately, now the entire debate is quite narrow on the IoT constellations. I really wonder whether we need to broaden up that, because there are certain other aspects that are simply not covered. And I think that would be it. I mean, surely, Michael, I mean, yeah, the industry doesn't necessarily have an interest in that. I do see that point, but being extremely utopian would rather mean what would be eventually the ideal state that we're looking at. And I mean, sure, there we could think a bit bigger, and international competitiveness and this kind of trade policy that comes with it is clearly one of the factors that drives the debate. And so I'm also wondering whether this should be kind of now considered in this current debate that we're having as well, and just broaden that idea to not only IoT constellations.
Thank you, Paul. I mean, I think it was a fantastic wrap up. We have 5 minutes left, so Pencho, I don't know if we have any questions from the...
Actually, it's everything is fine. If you have concluding remarks, we could slowly go to end with this session. I really enjoyed the discussion, but yeah.
No, thank you. I mean, I think we have some important takeaways here. I think that looking at this Data Act proposal or upcoming.
Yeah, 2 more minutes into if we could finish in 2 minutes would be good, or 3 minutes, let's say.
Okay, good. No, but I mean, I think we have important takeaways like this idea of this clear goal orientation, that it's key, and going beyond this dimension of
please go for it. Please go for it. You have 5 minutes. I don't want to disrupt this beautiful discussion. You're the moderator. Please go on.
Okay, I mean, I don't know if you can hear me because I was speaking. I'm sorry. So yeah, I mean, as I was saying, I mean, I think we have some important takeaways just to wrap up. I mean, there are other things that we could discuss, like we have this recommendation of the Council from the OECD that it's also there, that it seems more voluntary, approach towards B2B data sharing, the one that they call enhancing access to and sharing of data, that was recently published. But unfortunately, we don't have Christian here, and it will be great to have his view on that. But I think that from the side of the future or upcoming Data Act, both the remarks from Michael and Jörg are extremely valuable. So a clear goal orientation, I think those are key takeaway messages. The need for conceptualization, and I think that's also key, taking into account third-party rights beyond GDPR and also intellectual property rights. That's something, so it's some homework that we're giving here to the Commission, and we're at the right place, I guess, the head of representation. And also, think bigger. I mean, maybe instead of just narrowing down and maybe taking this purpose orientation, if we want to enhance data economy and also kind of independency, from a more strategic point of view, this idea that actually has also been mentioned in the recent Koalitionsvertrag that it's published last week. So I think those are, I will say, I don't know if my dear speakers then want to add something on top, but I think those will be the main takeaways from today's session. So I will say Pencho, I pass it over to you. I thank you very much for making this happening virtually, and I'm very sorry that we couldn't join you there in Berlin. Hopefully, next occasions we will have to be there in person. And yeah, that's all from our side.
Thank you very much. It was an experiment, moderation from Munich, and it worked perfectly. Thank you. We really enjoyed your discussion, and we really appreciated your views on the subject. Now, yeah. And hope to see you next time in Berlin.